Hello, nice to meet you. Hello. Hello. This is Richard Hill. Yes. Yes, absolutely. All right, so obviously this conference is held on a without prejudice basis. I'd like to just start with some of the facts in relation to my client's claim. So Mr. Hill had a meeting with your client back in February of 2015. During that meeting, he advised your client of the need to lay some tiles and so forth. Your client gave our client a number of recommendations and provided a quote. Your client made the following assurances. He told my client that he would use the best glue for the job, and he further informed my client that the best glue for the job was a cement-based glue, and this is because if you don't use a cement-based glue on wooden floors, there is a risk that the tiles may lift because they don't stick well to the timber. The work went ahead and payment was made, and then in or about, early July?
Yeah, that's right.
Early July, my client noticed that the grout was beginning to lift and break up, and he telephoned your client in relation to the problem, and your client came out and regrouted these spots. Another week went by and the tiles continued to break up, and my client telephoned your client and said, this is an ongoing problem and it's getting worse, and your client, this was the first time your client said to my client, well, if you'd chosen the right glue, this wouldn't have happened. The tiles are continuing to lift, and my client has obtained an expert report from Martin Briggs from Acme Flooring Specialists. Martin has said that the reason why the tiles continue to lift is because the cheaper cement-based glue was used, and eventually all of the tiles will lift on the floor. Martin's view is that the only rectification that can occur is that all the tiles are lifted and then they are relaid using the rubber-based glue. And that would cost approximately $70,000 plus GST. Since that time, the tiles have continued to worsen, and it's now the case that my client has another issue he is facing. He's very concerned that one of his customers may actually trip and fall in the premises due to the state of the tiles, and perhaps even sue him, which is obviously of great concern to him. My client doesn't have the ability financially to pay $77,000 to have this job redone, so it hasn't been done at this point. And it obviously is causing him some ongoing strain in relation to the state of the premises, given that it's a fashion warehouse. So that's probably sums up where we are at this point in time. Perhaps we could hear from you in relation to your client's version of the events.
All right, okay. It seems to me that really at the end of the day, what this is going to come down to is a question of who said what. And Mr. Barnes has been in this particular business for quite some considerable period of time. He's very experienced in this type of work, and really, he provided a quote to your client, which was for a job of some $67,100, being $61,000 for the actual work and then $6,100 in GST. And that was the only document that was prepared. And the document itself is quite clear. It sets out the scope of the work, and there's no reference in there to anything about cement-based glue. And the reason for that is that my client, Mr. Barnes, says that discussion never took place. It was really a case of your client wanted the work done, and indeed what discussions they did have centred around your client wanting it to be done at the cheapest possible price. And Mr. Barnes accommodated your client's request. Interestingly enough, when this problem that you speak about started to manifest, Mr. Barnes was quite prepared to come out and undertake to do some rectification work. He probably didn't have to do it, but he undertook to do it as an act of good faith. And it was at that occasion that he told your client had better or more appropriate glue been used, then this problem wouldn't present. And it seems that that is the time that cement-based glue was first discussed. There was no discussion about it being used in the initial discussions concerning the formation of the contract. And Mr. Barnes, of course, is aware of your quote. It's interesting that the rectification quote is some $10,000 in excess of the total value of the work done. And we've also had the opportunity of having an expert look at this, and he's provided us with an opinion. This is Mr. Jack Mitchell. And Mr. Mitchell, who in addition to his work in the tiling industry, has also for the last 5 years been retained by the Queensland Building and Construction Commission to undertake rectification works. He's inspected the site of the client's property, and he's formed the view that it can be done for much less than this quoted amount of $70,000. And indeed, in his opinion, and he's obviously an expert, it can be done for a price in the order of $2,000. So I guess at the end of the day, we're a long way apart, aren't we, Tanya? I mean, your client's saying 77,000 and my client's saying 2,000. And you know, can I just say we're sympathetic to Mr. Hill's predicament. We appreciate that this is probably an unhappy situation. But in our opinion, and based on what we know, it's largely come about as a consequence of your client wanting to probably cut a corner to try and reduce the price that the work was being done for, and there's been this undesirable consequence.
Well,
we're realistic.
Yes.
We're here today to discuss the prospect of settlement because I think both our clients realise that if this matter continues, there's going to be a large amount of expense involved in it, and I would think at the end of the day it's going to come down to a question of credibility, and as you know from your years in practice, assessments of credibility are very much left in the hands of the third party, the judge.
Yes, well, on that note, I mean, I would have thought your client was going to face quite significant credibility issues if the matter does proceed to a trial because of the sheer fact that his business was operating without a licence. I don't think any judge is going to be particularly impressed about a business operating outside of the law in that regard. And I appreciate that it's not a matter that's been pleaded, but on a credibility issue, I would have thought that poses some great risks to your client.
Well, I think my response to that is twofold. The first one is that at the material time, he did in fact have a licence, but it was a Victorian building licence. So he was a licensed contractor, and in the intervening period, he has obtained a Queensland licence. So obviously, the licensing authority has been satisfied that he's a fit and proper person. And I mean, this is really not an illegal transactions case, is it?
No.
At the end of the day, it's not that he's suing your client; it's your client suing him.
Yes. But my point would be that I don't think a judge would be too impressed with that, the reality of at the time that the contract was made. But notwithstanding that, you mentioned in your submission about the document being quite clear, the document that the parties looked at on the day. I mean, from our perspective, we don't understand why, if it was a case that there were two types of glue, your client wouldn't have specified which glue it was. And really that leaves that evidence open, another aspect of the evidence that will have to be proven at the trial. It's certainly not strong on the basis that it refers to no glue. So we see that as a difficulty that your client will have.
Sure. Look, I'm not going to get into a debate about who said what. I have pretty clear instructions on what the basis of the conversation is that the clients had, and as you've indicated, your client has a particular view of what was said. My client has a different view of what was said. And obviously, at the end of the day, it's going to come down to a question of which individual is going to be believed. But I think my client's aware of the fact that this is a type of exercise which is going to take up an inordinate amount of time. Much as we seem to get on well together, I'm sure his life would be much happier without me in it. And I'm very confident your client's probably in the same situation. I mean, this is a stressful
Yeah, he does want to try and resolve the matter if he can today.
Yeah.
A couple of points just to take up on what you mentioned earlier. I mean, this business about the cheapest possible price, obviously that's denied, and your client is in the position of being an expert, so it would be our submission at any kind of hearing that our client was entitled to rely upon your client's advice, and by not including the glue in the contract, and I don't see where a judge is inclined to find that a layperson would make a decision opting for a cheaper, less effective solution in circumstances where the expert comes in and makes that advice. But that's by the by. Jack Mitchell, I think, is that your witness expert?
Yes, that's right.
Yes. We understand that Jack's actually a friend of your client's.
He's acquainted with my client, but he's certainly not a friend. I don't think there's a close relationship. I mean, obviously, they're both very experienced individuals in the building industry. It's something where you would inevitably know each other, just as you and I know each other.
Yes, I think my point would be that, when it comes to a judge deciding at the hearing which expert he's going to believe, we feel that we have the independent expert advice, and that's going to be favourable to our clients' case.
And again, I think, Tony, the thing is that comes down to a question of who's going to be the better witness on the day. And, you made the point before about the fact that your client relied heavily upon my client. You know yourself in building cases, particularly cases involving paint. It's not unusual for painters to suggest or recommend to a client 3 coats of paint, and the clients to say, well, can it be done cheaper? If you say 2 coats of paint, the client says that'll do just fine.
But that 2 coats of paint is normally recorded on the quote, so that it's there in black and white. In hindsight, your client probably can see that including the type of glue on the quote would have probably alleviated some of the issues that we have today.
And I think we're very conscious of the fact that a situation has developed which is undesirable. I mean, obviously, things like this going to court can have a deleterious effect on my client's reputation. There is attendant publicity associated with these sorts of matters, and we're very conscious. We're very conscious of these considerations, which is one of the reasons we're here to discuss.
Well, I have obtained some instructions from my client, and he is prepared to try and resolve this matter. He has this growing concern about the state of the floor and the risk it poses to customers and staff. At this point in time, because of the nature of the work to be done to rectify the floor and the extent of the work to be done to rectify the floor, my client would be prepared to accept a lump sum, inclusive of costs, of $60,000.
Look,
it's obviously inclusive of costs and interest as well.
I think the problem for us with that is that we just don't see that figure. And whilst I accept that your expert says a $77,000 rectification piece of work being done, I think that's probably a reasonable, rather an unreasonable expectation. I currently have instructions from my client to make a proposal that we'd be prepared to offer $5,000, which on our understanding equals the cost of the rectification work which Mr Mitchell has suggested, together with a substantial component towards the legal costs that your clients incurred.
Well, I mean, $5,000 wouldn't even cover the legal costs that have been incurred, because it has been quite an expensive process to date. As you know, litigation is expensive. The problem we have with any minor amount of settlement is that it's a quick fix, and even if our client was to accept your client's expert evidence that the job can be done by inserting this glue in different parts of the floor, there's no guarantee that that would actually resolve that issue, and there's no guarantee that it won't keep occurring in time. So the quick fix, cheap option to rectify the floor is really not something that my client will consider for the purposes of this negotiation.
Well, I can tell you we're so far apart that at this particular juncture, it's unlikely we'll be able to resolve the matter, which means it's going to continue on and your client's going to incur additional expense.
I just think you need to lift it up a little bit from 5. I mean, it's a fairly minor amount given the costs incurred to date.
I think you probably need to come down a little bit from where you're at the moment.
All right. Well, I can speak to my client and see what we can resolve as far as maybe making another offer. All
right, thanks for that opportunity. We've obviously had some pretty serious discussions about where we're going to be in terms of this going down. It's going to last longer. We're probably looking at anywhere between 12 months to 18 months before we get this thing to a hearing.
Just because of the backlog and getting it ready for
You know
trial.
what it's like at the moment, the civil list in particular. The discussion I've had with my client, he's prepared to put forward a proposal to pay $25,000. Now, as I understand it from what you've indicated, your client wants this payment to be made pretty much immediately. Obviously,
The works have to be done. I mean, it's a risk now.
and we appreciate that, but also, it is the consideration of the volume or amount of money involved. And if your client wants this money quickly, then obviously the trade-off is that the amount has to be a little bit less. So I have instructions to make an offer, formal offer, of $25,000. That amount will be payable within 1 month, 28 days, I should say. And that will be in full and final settlement of this matter, with the addition of a confidentiality arrangement whereby the terms of this resolution of the matter will not be made public.
I'm pretty sure the confidentiality clause isn't a problem, is it? No. I think the amount still is, though. It just really isn't enough to cover the work that's to be undertaken. I have sought my client's further instructions, and he does want this job done as soon as it can be done, but it's the amount that's really the sticking point, obviously. We propose that your client pay $35,000, but we would give your client some time to pay, and it also would have to include a lump sum upfront payment. So a sum of, I think we talked about $5,000 upfront payable within a week, and then I think my client talked about a period of 3 months equal instalments after that date.
When we were outside, we took the opportunity, as you would have guessed, to look at margins, and I think we can accommodate that figure of $35,000. In terms of the time to pay, though, because of the significant increase in the amount, we'd probably be looking more at a 6-month period. It's not unreasonable given the vagaries of the building industry, and obviously one of the biggest vagaries, my client's income is dependent upon being paid by head contractors, and I think your client will probably understand that you can't always guarantee that money's going to be received as and when. It's not like working for wages. So our proposal would be that we'd be prepared to make the $35,000 payment, and I think we'd be prepared to, certainly I have my client's instructions that an initial payment of $5,000 could be made.
Yeah.
But we'd want a longer period of time within which to make the final payment, so 6 months.
All right, I think given that the amount has increased significantly, I think that that's something our client could cope with. All right, so the terms of settlement would be that the parties, that the first and second defendant pay the plaintiff the sum of $35,000 inclusive of costs and interest, with payments made as follows. So the first payment of $5,000 be paid within 1 week from today, 5 p.m. Obviously paid into our trust account by direct debit or otherwise a trust check.
I can arrange that.
All right, and thereafter the equal sum payments, which I'll calculate in a moment, on the month following that payment.
Yes, I don't think
over the next 6 months.
we certainly wouldn't look at a balloon payment.
No, and obviously the usual terms. So we'll have to put these terms into a formal deed of settlement, and that deed will include the fact that upon payment of all monies, the parties will sign and file a notice of discontinuance. So that will end the matter once all the monies have been received.
We're very much agreeable to that.
All right. Okay. Well, I think that sounds pretty good. Are you happy with those terms?
Yes, ma'am.
All right. Okay.
All right. Thank you.
Thank you. Thank you very much.
Thank you.
Thank you. Thanks, Mr. Barnes. Hello. So what you've just observed with that video is a sample of what a civil litigation alternative dispute resolution settlement conference might look like. You would have noted that the clients were present. That's quite significant. You need to really have clients present in most circumstances so that you can obtain those instructions on the spot. There are exceptions. For example, if you have a corporate client that might be out of the state, they might give you instructions to negotiate to a certain point, and then you have to seek their telephone instructions. A couple of tips and bits of information about the conference. So once the initial facts are stated by each of the parties, and usually the parties would separate into separate rooms, and it would be from that point on that there would be negotiations made. So you go off with your client and you seek their instructions about the offers and make counter offers and so forth. It's very important in practice that you record the instructions of your client at all stages of the settlement conference. So you might walk in with an offer, as I did, to settle for, I think it was 60,000, which is not much of a discount. You would have that in writing before you go in, saying, I, Richard Hill, authorise my solicitors to make an offer for $60,000 in full and final settlement of this action, bracket, including costs and interest, bracket. And then you might have some blank authorities with you for the conference, so that at any point there's another offer made, or even an offer made that your client wishes to reject, you can actually get your client to sign that. I think it's really important to do that, particularly with lay people clients, because you don't want them turning around next week and saying to you, I didn't really understand that process, I don't have that money, or I want more money. So it's really important to record your instructions. Mediations are similar to this, except with a mediation you actually have an independent mediator who is present, does give a lot more of a briefing at the beginning of the process and talks to the clients about what without prejudice means and how the process will go. The other difference being that once the parties have made their initial submissions, the mediator usually separates the parties into two rooms, and it's the mediator who literally runs up and down between the two rooms, collecting offers, conveying offers, advising that offers are either accepted or rejected. And also, more importantly, with a mediation, the mediator will take the opportunity to talk to your client with you, because it's just the two of you in the room, about their prospects of success, any issues that they see with the matter, and perhaps try and convince them why they should consider making an offer or accepting an offer. So that's the main difference with a mediation. And with a mediation being another person involved, then there's additional costs, and usually the costs of the mediator are split between the parties. So you now need to check your assessment instructions for this chapter and follow those. Thanks.